very grave accountability mechanism is invoked, it has to be invoked on the right occasion, on the right facts, on the right allegations. That it could be invoked because Linturi has refused to fall in love with someone, because Linturi has refused to marry someone, because Linturi has such a bad perception, because Linturi has such a bad reputation. It is to trivialize and, I dare say, Chair, to scandalize our Constitution. Chair, I seek your protection because when the other side was speaking, it was listened to in silence. And I said, I am not a young child. I know my limits. I am a married man, as I said, to a beautiful wife and 3 children. So I'm just doing my job. Let me be allowed to do my job without interruption.
Members, let us know that this is the closing remarks, and let us allow the Council to proceed without any interruption. Thank you.
Thank you, Chair. You were told the other reason, Honorable Chair, is because some lawyer issued a demand letter. And because this lawyer issued a demand letter accusing Linturi at the instruction of his client of some wrongdoing, therefore there are serious reasons. And I kept asking in cross-examination and examination in chief. Honorable Chair, I have practiced law for 17 years now and counting, and every day of my professional life for those 17 years, the very first thing I do in any assignment is to issue a demand letter. I don't know how many people would have lost their jobs if the letters authored by me on behalf of my clients were the new standard for having a cabinet secretary, and as I said, God forbid, even our street sweepers dismissed from office. That's the context in which I say we have been treated to a cruel joke. This joke is cruel because it invokes one of the most important provisions of our Constitution, and it invokes it in vain. You know, we have a commandment that says, don't invoke God's name in vain. And our Constitution is not just another document. It is the most important legal instrument in this republic. It is the supreme law. It begins in the first clause by acknowledging God. And here it is being invoked in the most frivolous, in the most trivial manner, because Linturi is, after all, such a bad guy. Where is the evidence, I dare ask? And I repeat, where is the evidence that supports either allegation 1 or allegation 2 or allegation 3? You know, Chair, it is not every material that a disputant presents to you that counts as evidence. When you read Section 2 of our Evidence Act, you'll find it says, evidence connotes the means by which an alleged matter of fact, the truth of which is subjected to investigation, which is what you're doing, is proved or disproved. What is the material or the means the mover deployed to prove or disprove the 3 allegations before you? And when I found myself reflecting on this again, Honorable Chair, it reminded me of a common adage, which again I didn't know. I first heard this adage when I was in the love market many years ago. And I recall a classmate of mine, me gesturing like young men do. I was a young man then, and I recall her telling me, Mudomi, beware what you pray for, as the gods may just grant it. It is a common warning. I think there is even a biblical version of it in the book of Acts of Apostles. Only that I said a man whose interaction with religious texts is sporadic. But the adage, Honorable Chair, says, beware what you pray for. Because God might just grant your prayer. What did the move of this motion pray for? Very passionately. He prayed that he be allowed to bring witnesses who had not even sworn any witness statements or affidavit. And this tribunal was gracious enough to grant that prayer. What happened after his prayer was granted? He brought Titus Kiprotich, who told us that he did not even know that his statement would be used in these proceedings. And he had not even read the proceedings. And he told us something even more curious. He did not even know the identity of the person who procured him to come and testify before you. He brought Bernard Kuria Wajiko, who told you without blinking his eye that he had not read even the motion and he did not know the allegations against the Honorable Linturi. This gentleman had bought a fertilizer called Mavuno, which is not even one of the fertilizers that are in contest. Then he brought David Maina, a man presented as an expert, I would say perhaps in his own imagination. He was not registered as a farmer. He was to come here and testify to you about some expert reports that he had not authored, that had been given to him by some lady whose name we were told, and that was supposedly used in the now famous, I dare say infamous, expose by Africa Uncensored. This guy proved nothing. He was incapable of proving anything anyway. Sami Kiptum Brigen also told you he had not even read the motion. He did not know what were the allegations against Linturi. He also bought that irrelevant fertilizer. Osea Kipkete Ruto, who was the last witness, also told you he had not read the motion. Some of these witnesses, when you read their witness statements, the reason they say the fertilizer was fake was because they used top-dressing fertilizer for planting. And then they tell you, as a result, the maize never grew beyond the knees. Of course, the maize will not grow beyond the knees if you use a top-dressing fertilizer as a planting fertilizer. Honorable Chair, when you make your decision, I pointed earlier, there is no recourse, there is no non-recourse against your decision in our legal system. And reading our Constitution, I'm now able to appreciate the wisdom of its drafters, Chair, when they said that the House shall form a committee to investigate, instead of simply saying the House shall vote. It is for good reason. And this good reason is that it is that tension in the Constitution between two things, democracy and justice. Those are core values of our Constitution, Honorable Chair, and they don't always pull in the same direction. Democracy will say, because the masses are telling Pontius Pilate, crucify him, never mind whether he has an offense, then, because that's what the people are asking for, you crucify the guy. That is democracy, the will of the people. That is the 149 votes. And I dare say it is because of this natural tension between democracy and justice that the drafters of our Constitution in their wisdom decided there shall be an inquisitorial committee and its proceedings shall be quasi-judicial. I'm saying there is zero room in Article 152 for lynching, for crucifying him, or for starting a chorus. You know, the problem with democracy, Honorable Chair, and why it is always at loggerheads with justice, is in democracy, you start a chorus, like before Pontius Pilate, crucify him, crucify him. If you go to any other democratic setting, like on the floor of the House, Linturi must go, Linturi must go. That's democracy, but it's not justice. And that's why this committee exists, to now walk that tight balance, because both democracy and justice are values in our Constitution, and I dare say, Honorable Chair, our Constitution has already decreed if there is a tension between democracy and justice, it is justice that prevails. That is why the right to a fair trial is absolute. When you read our Article 25, it says one of the rights that cannot be limited, not even by Parliament, not even by His Excellency the President, not even during war, not even during a state of emergency. The right to justice is absolute. Those are not my words. It is the words of our Constitution. I end so that I don't take away my learned colleagues' time by reminding you, Chair, because you're sitting as judges, I said last time, it is the only human enterprise where human beings take the seat of God to pass judgment against other human beings, to end careers, to end businesses, to separate families, to impose lifelong shame, to impose lifelong ignominy. It is only in the seat of a judge, which I dare say is the seat of God. Both dominant religions in this country depict God as the ultimate judge, and they even talk of a judgment day in which God seated on the throne will be judge numero uno, passing the ultimate verdict at the end of time on every one of us. And luckily, even this committee, for those of us who believe in religious texts, we shall also be judged that day for how we judged the Honorable Linturi. And I dare read, like I read last time, the hadith. We were told from Islam, judges are of three types, one of whom will go to paradise and two to hell. The one who will go to paradise is a man who knows what is right and gives judgment accordingly. But a man who knows what is right and acts tyrannically in his judgment will go to hell. And a man who gives judgment for people when he is ignorant will go to hell. That is the hadith number 3566 from Islamic teachings. When you're being told about farmers, which I've already told you, those cries cannot be the standard. You're being asked to act tyrannically. You're being told, like Pontius Pilate, to crucify this guy. You must crucify him. That's what you're being told. Because there were some 149 votes. And I've just told, even if there were 349, that would not be the standard. And of course, we were told in Matthew 7, do not judge, or you too will be judged. In the same way you judge others, you will be judged. And with the measure you use, it will be used to you. Why do you look at the speck of sawdust in your brother's eye and pay no attention to the log in your own eye? I beseech you, Honorable Chair and members, this motion before you is a petty calumny. It is a petty gossip about personal love and affection. It is a witch hunt. And because it is all those things, we would be scandalizing our Constitution on the occasion of today if we were to say the Honorable Linturi should vacate office merely because he has been a victim, as he told you, for 5 years of state-sponsored vilification, defamation, and shaming by the previous administration. I cede the remaining minutes to my very able and learned Boniface Mwereru Mawira.
Good morning, Honorable Chair and the members. It's afternoon, I'm sorry, good afternoon. I'll begin from where Dr. Mudomi has left. Honorable Chair, the linchpin or the substratum of this impeachment motion is what we are told is the approving. In fact, I think I should read verbatim. Approving the procurement and distribution of fake fertilizer. That is a substratum of the special motion before you. And yesterday during cross-examination, we pointed out Section 69(1) of the Public Procurement and Asset Disposal Act, which says that all procurement decisions by law, and none was forthcoming. So, Honorable Chair, for me, it's a question of principle. Can this committee, and to quote Dr. Mudomi, can this committee in good conscience advise His Excellency the President to dismiss the CS when this written approval has not been presented before you? Even worse, Honorable Chair, the procurement function, as by law, is a function of the Secretariat of the NCPB. The function of the CS ends in appointing the board. It is not the board, or rather the board members, that are directly appointed by the CS who are involved in procurement. Procurement is a function of the Secretariat. And the approved organizational structure that we presented before you clearly shows that there is a manager procurement and other competent officers below him or her who perform this procurement function. So that function cannot, by the mere word of the mover, be placed on the foot or on the door of the CS. There's another allegation, Honorable Chair, that was introduced midway. And I appreciate and commend my learned senior Dr. Amino for his contribution to the current constitution that we have as a country. But this same constitution says, under Article 50, I believe under Article 52B, that a man or an accused person has a right to know the charges that are pressed against him and to have sufficient detail to respond to those charges. So for me, Chair, it's really a question of, for how can the CS, because a lot of heavy weather has been created around this issue of the fertilizer, the board under the Fertilizer and Animal Foodstuffs Act, which allegation is not in the motion. For how can the CS be convicted with respect to a charge that is not in the motion? Is it permissible for the mover to introduce charges by word of mouth midway? Is it permissible for the mover's case to keep changing, to keep mutating, without giving fair notice to the CS for him to respond? That charge was introduced on the floor, and the CS responded on the floor. But by Article 50, being the accused person, the CS deserved the right to fair notice, the right to know the charge in advance, and the right to prepare an answer to that charge. So to the extent that that charge was not in the motion, then the CS cannot be convicted with respect to that charge. More importantly, Honorable Chair, and as we saw in Sonko, the Sonko decision by the Supreme Court, the allegations must be serious. To read verbatim, they must be serious, substantial, and weighty. All these allegations that we've been told about reputation, character, general responsibility, perception, all those allegations, they are not in the realm of specific acts that are attributable to the CS. There must be an nexus. And Honorable Chair, I am aware of the rule that you've made with respect to the issue of summoning witnesses. But allow me to say that when the mover was on the floor, the day he made the application for the PS, and I believe the CEO for KELS to be summoned, he said that, especially for the PS, he said it was necessary to summon the PS in order to establish some necessary links. And he had used some letters before this committee, most of which were not even copied to the CS. The CS was not even aware of those letters. So, how can it be possible then? And this is a question of law, Honorable Chair. The law on summoning witnesses is that you do not summon witnesses in order for them to fill missing gaps in your case. So to the extent that the mover sought to summon those witnesses to fill these gaps, to establish these necessary links, according to him, this is an admission that indeed he has not established the necessary nexus between the CS and the allegations that are stated in the motion. Honorable Chair, while Council was submitting, in her closing remarks, she talked about some former heads of state somewhere who have resigned. And I think it is important to make a clarification that there's a very rigid dichotomy between resignation and impeachment. Resignation is a question of political responsibility, while impeachment is a matter of law. In fact, if someone resigns, mostly it is voluntary, and that person can seek elective office in the future. But if you are impeached, as our constitution says, or if you are dismissed or removed from office, you face a sentence of eternal condemnation from public life, from public office. So the question, impeachment is a question of, first it's a legal question, and then there's an evidentiary threshold. It's not akin or similar to resignation. And we have seen, for instance, the example she made, President Jacob Zuma, he resigned. But last week, the Constitutional Court of South Africa cleared him to run. He can seek public office. But if someone is impeached, they are eternally condemned from public life or public office. And for President Zuma, there are specific acts. You know, all this story about the Guptas, about the rural home that was built for him using taxpayers' money in Kandla, somewhere in KwaZulu-Natal province, those were specific acts that were attributable to him. Council talked about the former president, I think, of Hungary, about clemency, the presidential pardon. That was an exercise, a specific act of the exercise of presidential powers of mercy. So even for these guys who resigned, there were specific acts attributable to them. And clearly, the threshold for impeachment is far much higher. It is not akin to resignation. Honorable Chair, we've been told about this expert. I'll just add something little over and above what Dr. Mudomi said. This expert did not even present the necessary credentials before you to prove that indeed he is an expert. Should we just take his word for it that he's an expert? Even more importantly, the report he presented before you was not prepared by him. He did not conduct the analysis, he did not conduct the testing, and therefore he is speaking about a report that was prepared by another expert, but not himself. Honorable Chair, the consequences of the decision that as you retire to make the decision that this committee will ultimately make, the consequences are untold, especially for the CS, because for him, he possibly, and I say the word possibly, stares at possible condemnation from public life, from public office. So is it proper, as a question of principle, for a mover to present witnesses before you, witnesses who have not read the motion, some are not even aware of who the CS is, witnesses whom I would say were duped. They did not even know that there was a motion, they did not even know the mandate of this committee. Can the mover properly say that he has proved his case to the required standard if these are the witnesses that he brought before this committee? Clearly, Honorable Chair, the mover has not discharged the burden of proof on his part. The burden of proof was on the mover. He told us that he needed some other witnesses to help him establish these necessary links, to establish these nexus clearly and admittedly. The mover was telling this committee that the evidence he has before you does not point, does not implicate, does not, state these specific acts that are attributable to the CS.